Good afternoon, and welcome to the Cobb County Board of Ethics meeting called here on May the 15th, 2023. First order of business is I would like to declare a quorum, which is of at least 5 members of the board. We do have all members present. First thing is to introduce ourselves, please, and the post that appointed you to this board. Okay, so starting with you, please, Cynthia.
Good afternoon. My name is Cynthia Smith, and I was appointed by Sheriff Craig Owens.
Winter Wheeler. I was appointed by Chief Magistrate Judge Brendan Murphy.
And I'm Carlos Rodriguez. I'm the chair of the Board of Ethics. I was appointed by the Probate Court, Judge Kelly Wolk.
I'm Ron Yonker, and I was appointed by the by the state court clerk, Robin Bishop.
Leilani Plendle, appointed by the Board of County Commissioners.
Janet Savage, appointed by Cobb County Tax Commissioner Carla Jackson.
Larry Cernovitz, appointed by Solicitor General of Cobb County, Metzger.
Lynn Rainey, Board Counsel.
Thank you, everyone. Next order of business is to administer the oath of office to our newest board member, Rabbi Larry Cernovitz.
All right, sir. If you'll raise your right hand, do you swear or affirm that you will faithfully administer and fulfill your duties as a board member as provided in the Cobb County Code of Ethics and is in the best interest of Cobb County, Georgia? If so, say I do.
I do.
All right, sir. Thank you.
All right, and the minutes for the last 2 meetings were disseminated among the board members for review. So I'd like to call on anyone to make a motion to approve those minutes from October the 19th, 2022. Is there a motion?
So moved.
Okay. Do I have a second?
Second.
Okay. Thank you. And without any discussion, I'll call the question to approve the minutes from October the 19th, 2022. Say aye.
Aye.
Any opposed? Okay. So, Mr. Rainey, the minutes from October the 19th, 2022 have passed. And same, on the same topic here for our last meeting, March the 13th, 2023, that was a special called meeting to consider a complaint that was filed. Those minutes were circulated among the members. Do I have a motion to approve those minutes?
So moved.
Okay. Do I have a second?
Second.
Thank you. I'll call the question. All in favor of approving those minutes from March 13th, 2023, say aye.
Aye.
Okay. Any opposed? All right, those minutes pass unanimously. There being no old business, Mr. Rainey, I understand that we have to conduct this task every year, which is the election of officers. The current officers are myself as chair, Mr. Yonker as vice chair, and Mr. Rainey as our recording secretary.
So that's correct. Under the code, we have to do this each year. So we can proceed either with one post at a time, or we can proceed with a slate if somebody wants to make a nomination for a slate of officers for the year. We can proceed in that manner as well. Whoever makes the motion first.
Well, I nominate the slate, to approve the slate.
Is there a second?
Second.
Okay. Any discussion? All for the motion say aye.
Aye.
All opposed? All right, sir.
All right, hearing none, then those positions will remain in place. And Mr. Rainey, I'm going to turn it over to you to introduce the pleadings and legal considerations for this board to consider, having received a complaint filed pursuant to the Cobb County Ordinance and Ethics Board.
All right, sir. The meeting of the Board of Ethics today is really for 2 purposes. One was for the regular business of the board. Under the Code of Ethics, the board is required to meet at least twice a year, once in May and once in October. So this serves as our required meeting in May. but we're about to transition into an investigatory review, which is a specific task that's put upon the board upon the filing of a complaint. So if you'll listen, hopefully this will give you a guideline of what you might expect to happen from here. The purpose of this public meeting of the Cobb County Board of Ethics, which is being broadcast on TV 23 pursuant to the code, is to conduct an investigatory review to consider a complaint filed by Lance Lamberton against Cobb County Transit Advisory Board member Matthew Stiegel. The Ethics Board is required to proceed strictly in accordance with the Cobb County Code of Ethics. We'll follow the rules set out in the code and will take such action as is authorized and required by that code. The board will be transparent, fair, and impartial to each of the parties. The next step under the code when a complaint and reply are filed is to conduct an investigatory review. We must meet in public to discuss the matter. The board members have not previously met and discussed this matter. The board members have received copies of everything the parties have filed and had the opportunity to individually review in the privacy of their own homes and offices. Today will be the first occasion that members will have to discuss the matter. Nothing has been decided. The sole purpose of an investigatory review is to, quote, to determine whether specific substantiated evidence from a credible source or sources exist to support a reasonable belief that there has been a violation of the Cobb County Code of Ethics. Mr. Lamberton and Mr. Stiegel, this is your opportunity to tell the Board of Ethics in person why it should either proceed or not proceed with this complaint. The Ethics Board will not be hearing your testimony or testimony from your witnesses during this investigatory review or considering affidavits, documents, or materials not already filed with the clerk of the County Commission and previously provided to the Ethics Board. The board will only be considering the filed written complaint of Mr. Lamberton, the written reply of Mr. Stiegel through his attorney, and filed affidavits, documents, and materials. You are invited to state to the board in this meeting how the materials already filed support or do not support a reasonable belief that there's been a violation of the Code of Ethics. Please understand, Mr. Rodriguez, the chairman of the board, has the responsibility to ensure this meeting proceeds in an orderly, civil, and respectful manner and within the bounds of the Code of Ethics. So he must retain the discretion to limit or terminate your presentation should it stray from matters subject to our jurisdiction. The board will hear first from Mr. Lamberton. When he's through speaking, it will hear from Ms. De Carrera, who is the attorney for Mr. Stiegel, who's here in the room. The board will then discuss the matter here in public and vote. If a majority of the board determines that specific substantiated evidence from a credible source or sources exists to support a reasonable belief that there's been a violation of the Code of Ethics, a public formal hearing will be set at a later date at which both parties will be allowed to testify under oath, present the sworn testimony of witnesses and evidence. If the board, after such a formal hearing, determines clear and convincing evidence shows any violation of the Code of Ethics, it may issue a censure or reprimand of Transit Advisory Board member Matthew Stiegel. It may also consider Mr. Lamberton's request for injunctive relief. However, if a majority of the board determines today that no specific substantiated evidence from a credible source or sources exist to support a reasonable belief that there's been a violation of the Code of Ethics, it will dismiss the complaint. Mr. Chairman, I yield the floor to you to preside over the investigatory review.
Great. Thank you for that intro, Mr. Rainey. As he said, Mr. Lamberton, we're going to hear from you first, and this is to the benefit of both parties. What I think has worked well in the past is after you make your presentation, Mr. Lamberton, to the extent that the board has any questions of you to clarify your position or to better understand your position, I'm going to invite the members of the board to make whatever inquiry of you at that time. And then once kind of that step is finished, we'll hear from Mrs. DeCarrera on behalf of Mr. Stiegel. And after your presentation, same thing. I'm going to invite members of the board to ask questions of you to clarify or better understand your position on the issue. And then at that point, we will then go into kind of our discussion phase, deliberations of the issue on the merits, okay? Mr. Lamberton, go ahead, please.
Can you hear me okay? Good afternoon, and thank you for giving me this opportunity. My ethics complaint against Mr. Stiegel is based upon what I surmise as a conflict of interest between Mr. Stiegel's advocacy for passage of a mass transit tax by forming an advocacy group, Cobb for Transit, while simultaneously serving on Cobb County's Transit Advisory Board, or TAB. And I'd like to take this opportunity to respond to the respondent's response to my complaint. It is claimed by Mr. Stiegel's counsel that my complaint was not timely and that the complaint was not filed within 6 months of the alleged violation. Yet in my affidavit, my complaint specifically referenced an action Mr. Stiegel took at a meeting of the TAB on October 24th, 2022. Yet my complaint was filed on March 10th, 2023, which is only 4 months and 14 days later, well within the 6-month requirement. Mr. Stiegel's response also claims deficiency in my complaint, yet when that was brought to my attention by Lynn Rainey, counsel to the Board of Ethics, in a letter he sent me dated March 20th, 2023, I addressed those deficiencies in a notarized affidavit that I provided the county clerk on April 10th, 2023. Pursuant to Section 2-78 of the Cobb County Board of Ethics, my affidavit addressed these deficiencies by being filed by a person as defined in Section 241 who is qualified to file a complaint before this board. Finally, I would like to respond to the claim that there be no conflict of interest between the dual role Mr. Stiegel has played as both founder of a pro-transit advocacy group and at least one action that he took as a voting member of the TAB. I base my argument on what I see as unambiguous language in the county's Code of Ethics. Under the Declarations of Policy section in 242 of the Ethics Board, quote, people have a right to be assured that the impartiality and independent judgment of public officials shall be maintained, close quote. As a public official on the TAB, how can Mr. Stiegel credibly claim to impartiality and independent judgment given his outspoken role in an outside advocacy organization? Under impartiality section 246 of the Ethics Code, officers must not, quote, officers must not take part in any activity that places them in a position of conflict between their interests that relates to their responsibilities and duties as officers, close quote. Under these two provisions, I maintain that Matthew Stiegel, in his role as an appointed officer of the TAB, is an ethical violation of the two aforementioned sections of the county's ethics code and should have, as a bare minimum, recused himself from a vote that he took on October 24th, 2022 TAB meeting, where he voted in favor of a resolution unequivocally recommending that the county support passage of HB 930, which would greatly expand mass transit in the county. In conclusion, let me respond to the allegation by Mr. Stiegel's counsel that my complaint is an attempt to deny his rights under the First Amendment. In truth, nothing could be further from the truth. My complaint has nothing to do with establishment of his pro-advocacy organization. But to do that and also use his position on a governmental body to help him achieve the same end is where I believe the board should draw the line with a recommendation that he recuse himself from any future votes on the TAB related to mass transit and other issues that may be supported by his group. So that's basically the long and the short of it. Thank you for your time. Yeah, and you have questions?
Mr.
for me?
Lamberton, if you don't mind.
Sure, I'd be glad to.
Staying at the podium there to respond to any questions that any of the board members may have. So I'm going to look to my colleagues on the board. Does anyone have any questions? If I may, is it your position that a public official, whether a county commissioner or an appointee to a board, that then becomes a public official that, within the scope of the county code, is required to be perfectly impartial on the issues? Or is it impartiality between the parties that are involved in a vote?
If I could just respond by maybe doing an analogy. Let's say there was an appointment on the Development Authority, and there was somebody on the Development Authority that, let's say, worked for Lockheed Martin, and there was a vote coming up on whether or not to issue bonds to Lockheed Martin. I would hope, regardless of what the person's personal position might be, that that person recuse himself from a vote because it is a conflict of interest. And I see a similar situation with what I've described here between the Cobb for Transit group and membership on a governmentally appointed board.
Well, what about an officer that has campaigned and lobbied for their role on either the county commissioner's board or on a board that is advocating for lower taxes, lower taxes, lower taxes? Should that officer be recused from voting to increase taxes because they have publicly made their position known?
I don't really, I mean, well, that is a fair question. I mean, I would think that would be something that would not be a conflict of interest type of thing, but it would be something that the voters would need to look at in that particular instance and say, hey, you've taken this position to lower taxes, and then you turn around and you didn't adhere to what you were saying. So that would be a job for the voting public to decide. But in my analogy with the Development Authority, I think we're talking about a different thing there.
Okay. So why would that example not be a conflict of interest?
What the one where
Someone has made an officer has made their position known.
yeah, and are you talking about
That I am in favor of lowering taxes, in favor of lowering taxes. And then there's an issue before the county commissioners.
Now-
That person is a commissioner, is an officer, and they're voting whether to increase or lower taxes. Obviously, their position is to lower taxes, right? Should they recuse themselves from that vote because they're not perfectly impartial on the issue?
I don't think your situation is analogous to what I'm dealing with, because are you talking about an elected Board of Commissioner member?
Well, so the code treats them the same, right? So an officer is someone that is elected to serve on the county commissioners board, or an appointee by the county commissioners to a board such as the TAB. The code applies to them exactly the same, right?
If that's your understanding of the code, I mean, I was just reading the code in its language, and my interpretation of that language is that there is a conflict of interest when you form an outside organization and you're a strong advocate for that, which is fine. That's your First Amendment right. But then to also kind of parlay that into pushing for the TAB to also strongly support the implementation of a transit tax, to me, seems to be a conflict of interest.
Is there something about the Cobb for Transit organization that you believe is not in the best interest of Cobb County?
No more or less than the organization that I head up, Cobb Taxpayers Association. I think it's wonderful that we have vigorous advocacy groups that are standing on one position or another. I think that the voters of Cobb County should have the opportunity to hear outspoken people who are articulate and want to make their position known, and then let the voters decide ultimately. But I don't like the idea of skewing the deck unfairly by bringing in, doing that, and at the same time being a member of the Transit Advisory Board and pushing for an agenda that you are pushing privately and personally on your own. And I'm not asking for much. I'm simply asking that in that specific instance, it is ethically consonant with what I see as my interpretation of the Board of Ethics Code, that individual should, in that instance, recuse himself from a vote on the TAB.
So my question, follow-up to that is, so if the gentleman was private in his thoughts and opinions, but yet believed that this was a good thing for the county and then voted, that was okay, it's the public advocacy that you have a problem with?
No, my problem is not public advocacy. My problem is, if you're being a strong public advocate in an outside organization, then you should recuse yourself from a vote on a governmental body that is dealing directly with that issue. Similar to the example I gave with the Development Authority. I mean, there are times when it is prudent and it's ethical to simply not vote on everything that comes before the TAB board, given your activism outside of that board.
And I understand your analogy, and if I was a Lockheed employee, I'm being paid as a Lockheed employee, which could affect my bonus if I had one, and other kinds of things. Are you aware of any financial advantage that this person, Mr. Stegall, has received as a result of taking this position?
No, I'm not suggesting that.
Okay.
All right, thank you, Mr. Yonker. Is there anyone else on the board? Yes, Mr. Cernovitz?
I just want to follow up with your analogy there. So if you were on a board in the county and they were taking a vote on taxes, on raising taxes or lowering taxes, which I think is to your point, would you feel that you would need to recuse yourself from that vote?
Let me give you another example. I briefly served on the library board, and if I formed an organization while on the library board, which was advocating for a 100% increase in funding to the libraries of Cobb County, and then I was pushing for a motion on the library board that it support a 100% increase in funding for the library, I would clearly see that as a conflict of interest. That's something that I should recuse myself from a vote. I should not be doing both, one or the other.
So the reason that you would need to recuse yourself is specifically because why?
Because, with the library board example, what I'm saying is I formed an outside organization, hypothetically, that's advocating for substantially more funding from taxpayers for the purpose of benefiting the library system. And then I serve on the library board, and I put a motion forward, which is exactly what Mr. Stegall did, put a motion forward saying that we should support my group's attempt to increase taxes, to increase revenue for the library system. I would think that that would be a conflict of interest.
Would there be then a financial gain for you or for the library system?
No, the gain would obviously be for the library. I'm not talking about any financial gain, regardless of, Mr. Stiegel is a nonprofit organization. I head up another organization, which is likewise the same thing. I receive no financial gain from that either. So,
Thank you. Thank you.
To follow up on Mr. Cernovitz and your example about the library board, if the members of the library board agree with, like 100% agree with the advocacy efforts of the nonprofit advocacy group
Right.
to which you're a member.
Or let's say a founder then, right? Or my example would be, I would be the person who would create that
Okay.
group. Yeah.
Let's say that the members of the board, all right, also support 100% the policy decisions and the objective for that library nonprofit advocacy group. Should the members of the library board who agree 100% with the founder be required to recuse themselves from a vote on funding libraries in Cobb County simply because they 100% agree with an advocacy group's position?
As long as they are not founders or board members of that group, then they should be able to vote on that if they so choose. I think there's a definite difference between forming an advocacy organization and proselytizing for a change in public policy.
Okay.
And voting on all of our boards in Cobb County. I mean, we hopefully hold them to a very high standard when it comes to their ethical determination and their behavior. And it's just sort of like, sort of using one to help the other is a little, to me at least, a little unseemly and inappropriate.
So I think you've answered Mr. Cernovitz's question, which is, specifically, what is it that you see as a conflict of interest? I think your position, if I understand it, is the role as founder on Cobb for Transit and board member on the TAB.
Right.
So it's the role of founder and board member.
Which I see as the conflict, sir.
Okay.
Yeah.
But you would agree there's not any evidence of a financial benefit to Mr. Stiegel?
No, and I've stated that already.
Okay. If there's not any financial benefit to Mr. Stiegel, then what benefit is there to Mr. Stiegel personally that would be a conflict of interest under the letter of the county code?
Well, I'm not saying that there's a personal interest. In other words, if the transit tax is put on the ballot and it passes, there's going to be any financial benefit to him, but certainly he may feel that it's a benefit to the county, and that's his point of view, and he feels that the county would be better served by that, and that's fine. As I say, forming advocacy organizations and being advocates for whatever your point of view is something that I would encourage all Americans to do if they feel strongly enough about it. But, that I'm not suggesting, and I'll repeat this again and again, I'm not suggesting any fiduciary conflict of interest. If that's the standard by which conflict of interest exists, then, yeah, then my complaint would be invalid. But I don't think, I think that we have to go a little deeper than that.
Mr. Lambert, I have a question. You mentioned earlier stacking the deck. What did you mean by that?
Say what?
Stacking the deck?
Stacking the deck, yes. In other words, you have a role to play as a transit advocate, okay? And it's well known, it's publicized, there's newspaper articles about you, they have a newsletter that they put out, so it's a strong advocacy effort. At the same time, you're working within a board, and there can be no doubt that you are, well, I don't think there could be any doubt that there would be an effort to influence, looking at the minutes that I have provided, that there would be an effort to influence the opinion and the vote of the TAB. And in fact, that is exactly what has happened.
And Mr. Stiegel is one vote, correct?
One vote, yes.
So if part of the role of being on that board is to enhance mass transit, I'm trying to understand if he's one vote.
I don't see a problem with the board voting a recommendation for the mass transit. There's other things that the board does as well. I mean, they look at scheduling and other amenities and things that are related to the service of public transit. So, yeah, there's not a problem. Now, it's one vote. Recuse yourself from one vote. Maybe that would have made a difference if the board was more evenly divided. But that's not the case in this case.
So it's okay if he votes on improvements
Exactly.
to mass transit. It's only until there is an issue with taxation that you feel like there is a conflict of interest.
That states it very well. Thank you. Yeah.
All right. Anything else from members of the board? All right. Thank you so much, Mr. Lamberton.
Thank you.
Appreciate it. Ms. DeCarrera?
Mr. Chairman, members, good afternoon. My name is Kimberly DeCarrera, and I'm here representing Mr. Matt Stigall. We're responding to the complaint that was filed by Mr. Lamberton, accusing Mr. Stigall of having a conflict of interest between his participation in a non-profit organization and his advocacy for public transit and his position as a board member of the Transit Advisory Board. Does this feel like deja vu all over again? We were here 2 months ago talking about this exact same issue with Commissioner Richardson. Both Commissioner Richardson and Mr. Stigall have nonprofit organizations on a political issue. However, just like with Commissioner Richardson on March 13th, there is no conflict of interest by having a nonprofit organization which the board member does not have a financial gain or benefit that's in opposition to the interest of Cobb County. I would also like to mention that unlike Commissioner Richardson, Mr. Stigall is a volunteer. The Transit Advisory Board has no authority to bind the county to any official action or contract of any sort. All right. All that the Transit Advisory Board can do is make recommendations to the Board of Commissioners, who then use their own independent judgment to make a decision. Mr. Stigall was appointed to this position because of his advocacy, because he is an outspoken citizen on a political issue. In the summer of 2019, Cobb for Transit was created as a nonprofit organization to promote public transit in the county. Mr. Stigall has been listed as an officer since its inception. He never tried to hide his affiliation with this organization. It is because of this advocacy that he was appointed to the Transit Advisory Board. That happened in March of 2021. Even Mr. Lamberton knew of Mr. Stigall's advocacy and his affiliation with Cobb for Transit at that time when he was first appointed. This is even evidenced in Mr. Lamberton's editorial with the Marietta Daily Journal on February 11, 2022, where he mentions Mr. Stigall's affiliation. Therefore, for any complaint to be timely, it should have happened within 6 months of Mr. Stigall's appointment. But here's the dirty secret here. Mr. Lamberton does not care about a conflict of interest for running a nonprofit organization. He didn't file a complaint when Mr. Stegall voted no 2 different times on the tax issue. He didn't file a complaint when he was first appointed. Mr. Lamberton filed the complaint once the Transit Advisory Board unanimously voted to recommend that the commission take the next steps in going forward with a referendum. The commission wasn't even voting for the tax. This is to put a referendum on the ballot in 2024 so that the citizens and taxpayers can make the decision. Lance Lamberton filed this complaint because he is against the transit tax. And when he didn't get his way, this complaint followed. In his remarks to the Cobb Republican Party 2 weekends ago, Lamberton admitted that he didn't have a winning case. He knows that. But he's using this ethics process to raise funds for his association. He's trying to set up a bad guy, a person on the other side of the issue for the referendum to come, for that campaign. Lance Lamberton knows that there is no conflict of interest here. He knows that this complaint was not timely, and he is wasting the resources of the Cobb County taxpayers by being here today. This is not the proper venue to fight a political issue, nor should the Ethics Board be used to punish a political opponent. Cobb Ethics Section 246 requires that officers cannot receive or retain any direct or indirect financial interest that puts them in conflict with the county. Subsection B specifically says that officers cannot use their positions to provide benefits, financial or otherwise, to themselves or to any for-profit organization. Mr. Lamberton was just up here saying that Mr. Stegall has received no financial benefit. All right, that is not a question here, right? And furthermore, we know that there's no conflict because both Cobb for Transit and the Transit Advisory Board have very similar missions, and that's to enhance public transit in Cobb County. Mr. Chairman, when we were here 2 months ago on Commissioner Richardson's complaint, you explained in the discussion portion that there is nothing that shows that Mr. Stegall has any employment or private interest that is incompatible with his public duty as a member of the Transit Advisory Board. Where's the conflict? Furthermore, this is a perfect example of what is wrong with our political discourse. In section 242B, it specifically states that it is essential to the efficient operation of government that those persons best qualified be encouraged to serve in positions of public trust. Who better to serve than somebody that's been a public advocate on an issue? All right. Moreover, it is the intention of the Board of Commissioners that this division be construed to accomplish this purpose and interpreted and understood as not to unreasonably to frustrate or impede the desire and inclination to seek and serve in public office by those persons best qualified to serve. Since this complaint has been filed, a story ran in the Marietta Daily Journal that had a picture of Mr. Stegall with his 5-year-old son. Now, I don't know which mother or father here wants to see their kid dragged into a political issue because of their own political beliefs. All right? But that is a definite discouragement to people to serve the county interest. What citizen wants to get involved in the political discourse if they know that they are going to be subject to an ethics complaint where they have to take time off from their job or their business, hire an attorney, and come down here to defend their ethics. It's not just defending their position, it's defending their ethics. All for a volunteer position. Again, this complaint was only filed after the third vote that Mr. Stegall took on a transit tax. It wasn't filed after the first two where he voted no, not to proceed. It was only after the third one that this complaint was filed. Remember that Mr. Stegall is an unpaid volunteer serving the county. He's using his knowledge and his expertise to better the county. There is no conflict of interest for having a public advocacy position, a nonprofit organization that he receives no financial benefit from. He's trying to make the county better. That is in line with the Code of Ethics and the mission of the Transit Advisory Board. Sustaining this complaint and proceeding any further is an absolute travesty and a waste of all of our time and taxpayer resources. This board should find that there is no specific substantiated evidence from a credible source to support a reasonable belief that Mr. Stegall has violated the County Code of Ethics, and the complaint should be dismissed. Furthermore, we ask that this board reiterate so that we don't have to come back here for a third time to discuss whether a member can have an advocacy interest in a nonprofit organization that they receive no financial benefit from. Thank you.
Thank you, Ms. DeCarrera. Does any member of the board have a question for her? Okay.
I'll just ask for clarification. In the ethics code, in section 274, there is definitions against and prohibitions against political activity. So under B, under permissible activities, when you scroll down, number 8 reads, be politically active in connection, which is permissible, with a question which is not specifically identified with a political party, such as a constitutional amendment, referendum, approval of a government ordinance, or any other question or issue of similar character. So when listening to your words, reflecting on section 274, do you believe that that would be in support of the advocacy work of your client?
Which section are you?
274.
274.
Talks about permissible activities, and number 8 specifically looks at advocacy, permissible activities that would talk about politically being active in connection with a question which is not specifically identified as with a political party. So talking about transportation, I think the ethical question that we're looking at here is that, is transportation a political issue, or is it something that should be a non-political issue for the advocacy and work of Cobb County?
Well, we know it's a political issue. First of all, we're here today, right? And Mr. Lamberton has made that. We're also going to have to go to a referendum on this issue. So we know that it is a political issue.
Right. However, according to 274, referendums are permissible activities to support on behalf of those who are on any Cobb County board.
Yes, they're free to engage in those activities.
So would you say that, referring specifically to the ethics code, would you say that that is what your client has been participating in then, which would make his activities public comments, then therefore permissible to then serve without conflict on any Cobb County board?
Yeah, we're saying that is a permissible activity, that we want the people that can have the best knowledge and expertise to serve on these advisory boards, bringing all of their experience and political desires to the board, right, to further enhance this issue. So all of that is a permissible activity under the Code of Ethics.
Thank you.
Ms. DeCarrera, You made it a point, both in your presentation, but also in in the pleadings filed, to note that Mr. Lamberton did not file this ethics complaint at the time of Mr. Stegall's appointment. And upon similar votes on this issue leading up to the October 2022 vote. Would you agree, though, that under Mr. Lamberton's logic, while it may make sense for him to have filed a allegation of a conflict of interest at those previous times, the fact that he didn't doesn't preclude the Board of Ethics from receiving Mr. Lamberton's complaint as timely? I mean, he is not alleging that the appointment is a conflict of interest under the county code or that the first two votes were in violation. He's simply alleging that the October 2022 vote is a violation. And that would be timely, right?
Let's see. Our position is that either there is a conflict or there is not a conflict. If there was a conflict, that has happened since his appointment, right? And that the complaint should have been filed then.
And it may illustrate your point that there's not a conflict, but as far as, well, you're suggesting that this is a waste of time,
Yes.
okay? And that perhaps this board should have decided that the complaint was untimely and perhaps not even give an investigatory review, this type of hearing, to even acknowledge or review his complaint, right? I mean, that's essentially what you're saying.
Yes.
But there's nothing in the code that prohibits Mr. Lamberton from filing this complaint at the time that he did, as long as it is within a certain time limit from the allegation of a conflict of interest, which he did, right?
Yes, he filed within the 6 months of the October vote.
Okay. Once that's done, I mean, this board doesn't decide on the merits before having this meeting. And you would agree this is what
Yes.
the board has to do once the code has been satisfied, which Mr. Lamberton's complaint satisfies the requirements of a complaint in the county code.
Yes. It is actually our position that Mr. Lamberton is wasting the taxpayer resources by filing this complaint, by pursuing the complaint.
And I'm not going to weigh in on that. I suspect this board isn't going to weigh in on that because he's simply doing what the county code allows the public to do. And we're simply, as a board, doing exactly what the code requires of us to do, which is give you an opportunity to respond, which you've done very, very
Right.
well, and give Mr. Lamberton an opportunity to respond to his position. Whether one party prevails or doesn't, I think I can speak on behalf of the board. We simply want to give you an opportunity to be heard. And both sides have followed the filing requirements under the county code, and it has properly triggered this meeting. Well, that's all I'll
Okay.
comment on. Does anyone have any other questions of Ms. DeCarrera? Okay, all right. Thank you, ma'am. So at this time, I would invite members of the board to share their thoughts, perspectives on how the county code should inform our decision. And the issue, I think, is pretty narrow. I think the parties have done a pretty good job of narrowing the issue, whether Mr. Stegall's participation on a nonprofit, Cobb for Transit, while also voting on a measure in his capacity as a board member and an officer under the county code constitutes a conflict of interest. I think those members of the board that ask questions of the parties are certainly, it's obvious to me, y'all are honing in on the issue to be decided today. Who wants to start? Thank you, Cynthia.
Well, I think the main reason why we're here again is a good point that anybody could make a complaint. That's why we're here. And I didn't hear anything about financial gain. And I think that's why we're here also, that you could have a nonprofit and be on a board of something that you support and be an advocate, but not getting a financial gain based on the vote that somebody else don't like, based on you stacking the deck.
Thank you, Cynthia. Where?
I just don't feel that I've seen any evidence of an actual conflict here. It seems that Mr. Stigall's actions are in line with what that board is designed to analyze. I was further moved by the fact that this is just an advisory board. They're not making decisions.
Let me share what I view as a concession on your part, Mr. Lamberton. You have conceded that the mission of Cobb for Transit is for the presumable benefit to the county. There would therefore not be any conflict of interest from a non-financial standpoint, given that concession. Now, I don't know anything about Cobb for Transit beyond what has been presented by both parties. And my view is strictly narrowed by what you have been presented to me. But I think your concession today is telling. He doesn't stand to gain anything financially. I think your phrase was, there's no fiduciary conflict. But if his role on Cobb for Transit is with a mission designed for the benefit of Cobb County, then that's exactly what the Code of Ethics requires of these public officers. So I won't weigh in on what Ms. DeCarrera may suggest is your subjective intent in filing this ethics complaint. I don't frankly care subjectively what your intent may be. Just looking at your complaint, what's alleged, and your concession here today, in my mind, I think that really makes clear, and in your words, unambiguous under the county code, that there's no violation here. That's my thought. Ron, do you have any?
I also haven't seen any evidence on how this board affects other costs like fares and other things by making recommendations to improve equipment, to purchase buses, to, and that's out of the purview of this particular hearing. So from what I've heard, I don't see a financial, if he was a member of and employed by a vendor or some, but I don't see that. In fact, I was just thinking the opposite. If the commissioners only picked people that they knew were against the committee in which they were being appointed, I mean, that just doesn't make sense to me. But an advocate has some sense of the concept of mass transit, right? And so would be someone they might put on that board, who could then weigh in with their opinions and perspectives, whether it be public or not public. And so I don't see right now in my mind a conflict.
As stated, I agree. I just don't see any gain that Mr. Stegall has gotten from this, and I thought I might have seen something more than what had already been presented to us, but I didn't see that here today.
I am in agreement with the rest of the board, and I am very appreciative to our citizens that choose to serve as volunteers on our boards. And I think if we were to see this as a conflict of interest, most of our boards would not have members on them. And again, I think we cannot forget that Mr. Stegall has one vote. But again, as my cohorts have said, I see absolutely no conflict of interest and no opportunity for monetary gain.
Thank you, Janet. Mr. Cernovitz?
Yeah, I would echo, I don't want to repeat what we've all said, but I think the strength of Cobb County is its residents and what they care about. And by appointing people who care about certain things or have expertise in certain areas, we only enhance our county. And expertise shouldn't eliminate somebody and cause a conflict of interest. I also believe that in our ethics code, our people who are on our boards should have feelings about things. That's what we want. And to engage in dialogue, which only betters the county, is only better for us all. So I also would reiterate what you've all said, is I don't see a conflict of interest either.
And the last thing I'll say, and I was even more persuaded by what you pointed out, Mr. Cernovitz, which is the provision in the county code on the permissible activities of an officer, a public officer. I think that the county code expressly permits the sort of involvement, advocacy for questions such as mass transit. And having an opinion, an impassioned one as it may be, is explicitly permitted activity for a public officer. I think that's unambiguous under the code. And certainly, Mr. Stegall could have pointed that out in his response. But I think that the county code, as it is written, the black letter of it, permits this very sort of position to be taken. And I don't think that the county code requires impartiality on the issues. I think it makes clear that impartiality on the issues is not required. The impartiality that is required is to avoid conflicts between personal interest and the county's interest, financial interests, and avoiding partiality towards a certain individual at the expense of the county's benefit. Those are the sorts of conflicts of interest that the county code seeks to prohibit, okay? So at this time, I'm going to call the question. Let me get the language right explicitly here. Thank you. So I'm going to call for any member of this board to make one of the two motions: to find specific substantiated evidence from a credible source to support a reasonable belief of a ethics violation, or a motion to find no specific substantiated evidence from a credible source to support a reasonable belief that Mr. Stegall has violated the Cobb County Code of Ethics.
I
I
move
move that we, sorry. I move that, sorry about that. I move that we find that no specific substantiated evidence from a credible source exists to support a reasonable belief that Mr. Stigall has violated the Cobb County Code of Ethics, and accordingly, Mr. Lamberson's complaint is dismissed.
Do I have a second?
I second.
Okay. Unless there is any further discussion beyond what has already been shared by the members of the board. Seeing none, I'll call the question. All in favor, say aye.
Aye.
Any opposed? Hearing none, then the motion carries unanimously. I think the next order of business is to set the Cobb County Board of Ethics meeting for October. Do we have a date scheduled, Mr. Rainey?
October 18th at 3:30.
Okay. Here in this room, also televised to the public on TV 23. And at this point, I will entertain a motion to adjourn.
I make a motion.
Okay.
I make a motion to adjourn.
Motion from Ron.
Second.
Second from Leilani. All in favor to adjourn, say aye.
Aye.
All right. This meeting is adjourned. Thank you so very much. Appreciate the party's presentation.